Hello, everyone. Welcome back, class. This is Professional Responsibility. You know me. I'm your friendly neighborhood bar grievance defense attorney, Patrick John McGinley. I'm a member of the Florida Bar, where I am board certified by the Florida Bar in appellate practice. I'm a member of the District of Columbia Bar. I'm a member of the United States District Court for the Northern, Middle, and Southern District of Florida. I'm also a member of the United States Court of Appeals for the 11th Circuit and several other courts of appeals. Hey, what am I doing? Am I soliciting work from you by mentioning all this? Well, that's the topic of today's lecture. Specifically, we're going to talk about solicitation. When we talk about solicitation under the model rules, we're referring specifically to Model Rule 7.3. And we know that because the title of Model Rule 7.3 is Solicitation of Clients. So we can be confident that that's the rule we need to turn to when it comes to solicitation. But don't forget from our last lesson that there are at least two other rules we need to keep in mind when it comes to solicitation. One would be Model Rule 7.1, and that talks about communicating about a lawyer's services. Model Rule 7.1 doesn't just apply to advertising. It talks about any kind of communication regarding the lawyer's services. And the requirements of 7.1 can be summarized as such. Can't be false, can't be misleading. So that communication, that is your solicitation, can't be false or misleading. When is it false or misleading? When it omits a material fact or makes a material misrepresentation. How do we know whether the omission or the statement is material? Well, the model rules remind us in the comments that if there's no reasonable factual foundation, then that means it's a material fact or omission. And if it's false or misleading, it's a violation of Rule 7.1. Let's not also forget Rule 8.4, which I've called in so many other lectures sort of a catch-all for general dishonest behavior. So if you are acting dishonestly while soliciting clients, you're violating more than just Rule 7.3. You're also violating Rule 8.4. So now, what is solicitation? You remember the definition I gave in the last lecture. Solicitation is a communication regarding the lawyer's services to a specific potential client about that potential client's known or suspected specific legal need. So is there a line between solicitation and advertising? Yeah, the advertising is also a communication about the lawyer's services, but it's a broad dissemination offering legal representation. It's the specificity where we draw the line. When we're talking about a specific potential client and that potential client's known or suspected specific legal need, that's a solicitation. Do you remember the quintessential example I gave in the last lecture? I talked about the Good Samaritan lawyer who stops at the scene of a motor vehicle accident, renders enough help so that the driver who's injured in the accident expresses their thanks. How can I repay you? And the lawyer responds with a business card and a request that they be hired for that particular automobile accident by that particular potential client. That's a solicitation. I also mentioned under that hypothetical that it's probably a violation. How can we avoid that situation being a violation? Well, the lawyer can meet the burden of proof that they were soliciting pro bono work under Rule 7.3. It might meet the definition of solicitation, but it's not the type of solicitation that will subject the lawyer to discipline. If there was no incentive or goal of pecuniary gain by that lawyer, if that lawyer wasn't trying to make a buck, if that lawyer was doing pro bono work. So McGinley, are you trying to say to me that I can go out and solicit pro bono work? Yes. Yes, you can. Where else can I behave in such a way that the behavior meets the definition of solicitation, but it won't subject me to discipline? Former client or any other individual with which you have a former or current professional relationship. That's not solicitation. Close friend. That's not solicitation that will subject you to discipline. Relative. That's not solicitation that will subject you to discipline. Parent or spouse or child. That's not a relationship. I'm sorry, that's not a solicitation that will subject you to discipline. What about employment resulting from participation in an activity where you were trying to educate people about the law? That is not a solicitation that will subject you to discipline. So you might want to begin your videos by pointing out that you're a member of the Florida DC Bar and several other courts. If you're a friendly neighborhood bar grievance defense attorney like myself, have you noticed I do that? I hope you forgive me for it. In class, are there other instances where the lawyer's behavior meets the definition of solicitation but will not subject the lawyer to discipline? Yeah. What about there's a class action and then there's a joinder of others in the class and your employment resulted from the joinder of others in the class? That won't subject you to discipline under the model rules. What about no fee whatsoever is taken? Guess it's another way of saying pro bono work, right? That won't subject you to discipline, even though the behavior meets the definition of solicitation. Here's one. What if the communication or activity that meets the definition of solicitation is directed solely at your fellow lawyers? For example, what if you are your friendly neighborhood bar grievance defense attorney? Obviously, you defend other lawyers, right? So pointing out that you're your friendly neighborhood bar grievance defense attorney, I don't know, even if it meets the definition of solicitation, which I don't think it does, just saying what you practice in. Even if it does, it's not the kind of solicitation that's going to subject you to discipline. So, solicitation has a specific definition. But even if the definition is met, the next inquiry becomes, does that solicitation subject you to discipline? That's why it was important to discuss instances like we just did, where even though the definition of solicitation is met, the lawyer isn't subject to discipline. When you take the MPRE, the Multi-State Professional Responsibility Exam, which is something everyone in the class is going to be doing very shortly, you got to keep that in mind. Don't stop and answer the MPRE question immediately after determining whether the behavior was solicitation. Instead, also determine whether that particular solicitation will subject the lawyer to discipline. Don't let the MPRE trip you up by you failing to take the second step and ask that question about whether the solicitation subjects the lawyer to discipline under those MPRE facts of that MPRE question. So say you've got that prior professional relationship, and I'm talking about a professional relationship. Then the behavior might be solicitation, but it's not going to subject you to discipline. Have you seen lawyers gather, whether it's for bar meetings or for trade meetings? Those lawyers who gather for such things, and you're there because you're a lawyer. You're there because you go to a bar meeting because you're a member of the bar. You're there because you go to that trade group because you represent folks in that trade. You want to better understand what they do for a living, what issues they encounter for a living, how to express your legal advice in the terminology that is the vernacular of their trade or profession. That's why you're at these conventions. That's why you're at these bar meetings. And you'll be there, you'll do some networking, and you'll develop professional relationships. Once that professional relationship is developed, then you can go forth with direct solicitation without fear that soliciting that particular potential client will subject you to discipline, because you're going to meet that exception, if you will, for a prior professional relationship. Now, I would recommend going to family reunions regardless of whether or not you're a lawyer. But as a lawyer at the family reunion, you can also talk up your legal skills and offer your legal services. If you're offering pro bono, hey, you're not going to be subject to discipline for that solicitation. If it's a family member you want to charge, you'd have the right, because that family relationship means that you can solicit those individuals. Maybe you're just out of law school. You need that first client. Maybe a family member wants to throw you a bone. Maybe you want to check in with them and see if they will. That's not solicitation. Must it be face-to-face in order to meet the definition of solicitation? No. Any direct communication to a potential client about that potential client's known or suspected specific legal need, that's going to be solicitation. I don't care if that's a Facebook Messenger message, if that's a tweet, if that's a text message, if that's an SMS, if that's an Instagram message, if that's a FaceTime call, if that's a telephone call on a landline, a telephone call on a cell phone, a telephone call through your desktop with a voice over IP program. Technology is constantly evolving, and the technology is not going to decide whether or not it's solicitation. Instead, it's going to be whether or not you're reaching out to a specific potential client about that specific known or suspected legal need of that potential client. That's going to decide whether it's solicitation. Another exception would be a lawyer referral service. Prepaid legal used to be common. I'm not sure that it still is. Prepaid legal refers to, it's almost like an insurance plan. It's when it was common, it was often a fringe benefit of employment. The employer would buy membership into prepaid legal for its employees. And then the employee was entitled to X number of hours free of charge from a lawyer who either is employed by the plan or is a member of the plan as a provider. So this can avoid solicitation insofar as that's going to help you develop that professional relationship. It may even turn that individual into a former client. And once you've got the current client or former client having purchased certain legal services, you can go back to them, try to purchase again. Let me pose this hypothetical. Imagine a lawyer writing wills for clients. As the lawyer's been practicing for a year, 2 years, 3 years, 5 years, 10 years, 12 years, the number of wills in the file cabinet is adding up. And the wills in the file cabinet are getting old. Hopefully that lawyer takes pride in her or his work and makes sure that the wills are built to last as best as possible by taking into account foreseeable contingencies. But not everything in life is foreseeable. Some say life is what happens to us while we're busy making other plans, and that can be true for our current former clients too. What if the lawyer wants to go into his file cabinet, pull out the old wills, see the contact information, call those individuals and see if they need a new will? Does that meet the definition of solicitation? Most certainly. Is that solicitation that will subject the lawyer to discipline? Most certainly not. No. That's not an example of a solicitation that would subject the lawyer to discipline because of the prior professional relationship and the status of those individuals as being either current or former clients. What if, like me, you're board certified in appellate practice and you go to a bar meeting and you talk to other fellow members of the bar and offer to help them with their appeals? Well, there, that behavior meets the definition of solicitation, but it is not a solicitation that will subject the lawyer to discipline because that solicitation was made from one lawyer to another lawyer. Under the model rules, a solicitation from one lawyer to another is not a solicitation that will subject the lawyer to discipline. So you're a new lawyer, you're just starting out. Do you want to work the phones and talk to other lawyers? See if there's any type of case they might want to refer to you right now, or let them know about what areas of the law they might refer to you in the future? Sure, why not? That behavior meets the definition of solicitation, but it's not a solicitation that will subject you to discipline. Here's a hypothetical for you. You're a newly minted lawyer and you'd like to be employed. So you look up the contact information for the Human Resources Department and the name and contact information of the hiring manager for several major companies. And you send your polished resume with a cover letter asking that it be kept on file in case there are any openings for in-house counsel, because you'd like to be considered when such an opening arises. Are you subject to discipline for that behavior? The answer is no, because that is not solicitation. Remember, the definition of solicitation was a communication about a lawyer's services to a specific potential client about that specific potential client's known or suspected specific legal need. That behavior didn't meet the definition because you were just a potential employee looking for employment. Even though we're members of the bar, we still might want to get hired on a W-2 as an employee by a major corporation. And it's okay for us to use the usual means of contacting the human resources department and the hiring manager and throwing our resume into the pool in case we're needed in the future. That isn't something that meets the definition of solicitation. Compare that to the lawyer who's watching the evening news and sees that, I'll try to remember a news story from the past, hope I get all the facts right, sees that a particular airline dragged a client out of their chair and down the narrow airplane hallway and off the plane, causing that flyer to not only miss their flight, but to suffer personal injuries. If that hypothetical scenario were true, could you reach out to that corporation about that specific incident and offer your legal services? No, that meets the definition of solicitation. And do you see how the specificity of the incident and the need makes that contact with the corporation a solicitation, whereas throwing your name into the pool of potential resumes to be considered for the next hire does not? Do you see how the specificity makes that different? That's what makes it different, the specificity. So when it comes to soliciting clients, got to watch out for pecuniary gain. And you have to not, on these MPRE questions, be deceived by an emphasis on the media or the medium of communication. The model rules go so far as to talk about in-person and live telephone, and a phrase the model rules use, real-time electronic contact. I think what the model rules there trying to do is to pull in the Facebook Messenger, the SMS, the text messaging, the various ways that we communicate using our cell phones and our mobile devices. So don't be fooled by a focus on the technology, because there still can be a solicitation. Now, what about this scenario? And this thankfully happens to me all the time. A lawyer knows someone, perhaps it's their client, who needs to file an appeal. And the lawyer calls me and says, "Hey, Patrick, my client, Mrs. Z, needs to file an appeal. Here's her number. Can I call Mrs. Z about her appeal?" And the answer is no. That would be a solicitation, and it would not meet any of the exceptions. It's tempting to think, well, the lawyer represents that person, and therefore I can call this stranger because their lawyer told me to. But you're doing more than walking the line. You're crossing the line into solicitation if you call that person. So with that said, what do? You're in the thankful situation of another lawyer wanting you to have this appeal. Here's what I do. I say, "Hey, Joe, thanks for the call. But you know me, Mr. Ethics. And I know you're as ethical as I am. I'm worried that it might be a solicitation if I give her a call. Do me a favor. Tell her to call me. That solves the problem. Why is that? Because if the potential client contacts you, that is not solicitation. It does not meet the definition of solicitation if the potential client calls you. Now, in that scenario, the potential client's going to call me at the recommendation of this other lawyer. Is it solicitation if a potential client calls you at the recommendation of another lawyer, or at the recommendation of a neighbor, or at the recommendation of a friend, or at the recommendation of your mother? And the answer is, as long as the potential client is the one calling you, it is not solicitation. Doesn't matter who recommends you. Indeed, before there was lawyer advertising, there were recommendations. There was word of mouth. That's how lawyers got clients. And in today's world, that's still a noble way of obtaining a client. Maybe it's the most noble way for a fellow lawyer to recommend you, or the public at large to recommend you. Don't you want to have a reputation so noteworthy that people recommend you? Of course you do. Doesn't the bar want clients to find lawyers who are recommended to them? Of course they do. So long as it's the potential client that contacts you, it's not solicitation, even if the reason the potential client contacted you was because you come highly recommended. It's a good thing to come highly recommended. Let's take another look at that scenario of being in the right place at the right time. Imagine, if you will, this scenario. Lawyer just happens to enjoy hanging out in the lobby of a hospital. And lawyer, being warm and big-hearted, takes great joy in comforting those in sorrow in the lobby of the local hospital. And by doing that, develops relationships, which sometimes reveal that the sorrow of that person in the hospital lobby is because their loved one was injured in an accident where someone else was the tortfeasor, someone else was at fault, or their loved one suffers a wrongful death at the hands of a tortfeasor. Now, that lawyer developed a relationship, so can that lawyer solicit the clients? And under those facts, I hope you can see that that would be the kind of solicitation that would subject the lawyer to discipline. That would be improper. That would be what the non-lawyer would refer to as ambulance chasing, would it not? There's something to be said about the lawyer striving to be in the right place at the right time, such as my prior hypothetical where I talked about lawyers going to bar events and meeting other lawyers, or lawyers going to trade events and being active in trade groups, or lawyers being on a board of directors and offering free services to the corporation and thereby developing a relationship with the other directors who are doing the same. There's a difference between professional activity and activity that is taking advantage of others. In my hypothetical, the lawyer just happened to like to enjoy hanging out in the hospital lobby. Obviously, the lawyer's motivation in that hypothetical was to take advantage of others and to try to skirt the rules. So if we look at the official comments to the model rule 7.3, we see that paternalism. We see that effort to have the rule through these comments interpreted in such a way to prevent intimidation, overreaching, undue influence, and not to interpret the rules in such a way that all it takes is to hang out at hospital lobbies or hang out at accident scenes and thereby be entitled to solicit victims. Indeed, the Supreme Court of the United States has held, in a case involving the Florida bar, that was not a violation of the lawyer's rights under the U.S. Constitution or otherwise to say that direct mail solicitation to accident victims can't take place within the first 30 days after the mass tort accident. That was part of that paternalism to avoid that overreaching or that intimidation or that undue influence that can arise from solicitation. So when we look at solicitation, we're looking at the lawyer's motivation. We're looking at whether there's a pecuniary gain, but we're also looking at the government's right to protect against undue influence or overreaching or intimidation or things of that nature. So when it comes to preventing solicitation, it is in the public interest because we're trying to protect the public. Lawyers can be persuasive. Indeed, part of being a good lawyer is having the power of persuasion. But when that power is used to sign up a client, it's fair for the government to put reasonable restrictions upon how we use that power. And that's what we're talking about when we talk about Model Rule 7.3. I hope these hypotheticals and this explanation of Model Rule 7.3 helps you to better understand what you need to know about solicitation in order to pass the multi-state professional responsibility exam and in order to do well on the exam I'm going to give you in my class. If I've left any questions unanswered, please reach out to me and contact me in the usual way. I will get back to you promptly. I'm here to serve. I'm thankful to have this opportunity to teach you, and I'm thankful that you're in my class. Until our next lecture, may God continue to bless us all. I will see you soon. Thank you.